Some say we're always early with the live streams and always late with the premieres. But ladies and gentlemen, it is January the 1st, 2026, and this is the Court Gallery. I had a feeling you'd be listening, Marty. Ladies and gentlemen, Happy New Year. Welcome to the Court Gallery for a whole new year. We had no court today to really speak of, but there was court yesterday. That's right, on December 31st. And in the interest of playing catch up, after a long night of the New Year's Eve marathon last night, we're going to get caught up with some December 31st court cases, and we're going to start in Ann Arbor, Michigan with, oh my Lord, I don't even remember the judge's name, and I know it's in the description, so check the description for the information on the cases we're watching tonight. We'll be winding most everything up today in Kansas, though, starting with Judge Crum. In a pretty interesting civil case involving a cattle ranch, a farm, I don't know. There's some lockout stuff going on and a lot of discussion. I thought it was interesting. I hope you find it interesting too. The main body of tonight's program is definitely going to be dedicated to Judge Ricke and the theft of a certain motorcycle in El Dorado, Kansas. Ladies and gentlemen, as far as I'm concerned, it's all interesting. If you don't understand what's going on, again, check the description for timestamps and a little bit of an explanation of what's coming up. It all starts right now.
Good morning. Are you Ms. Ross?
Yes. Good morning.
I'm Magistrate Garwood. I'm going to be handling your case today. You're here today on AAPD 25-658H2. Tell me your full and complete name for the record.
Gail Leah Ross.
Thank you. Ms. Ross, a little bit of housekeeping. The courthouse is closed to the public today. The public has the right to hear and see what's happening here in the courtroom. So our cases are being broadcast live on our YouTube channel. When we're done here today, everything's going to come off of the YouTube channel. Next, the camera in this courtroom's in an odd spot, so it looks like I'm not looking at you. I'm looking at a monitor so I can actually see you. And last, we're doing this by Zoom. If something happens that you can't hear me or see me, let me know right away. Otherwise, I assume the connection's working just fine. Do you understand?
Yes.
Very good. Ms. Ross, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, the court will refer you to the local appointing authority for them to make investigation as to representation. You also have the right to a trial. Do you understand your rights?
Yes.
Very good. With that, we'll proceed with appearances. We'll start with the people.
Katie Rosmersky for the people.
First Assistant Public Defender Kalina Anderson with on behalf of Ms. Ross. Your Honor, we'd ask that you read the complaint at the appropriate time and stand mute.
Thank you. The complaint in this matter alleges that on or about December 31st of 2025, that you were in the city of Ann Arbor at Platte Road. It's alleged that you did make an assault and battery upon Naji Rashad Shafi. That is a misdemeanor charge with a maximum penalty, 93 days in jail and or $500. Do you understand the charge and the maximum penalty?
Oh, yes.
Thank you. The court will have you stand mute. I'll enter a plea of not guilty for you. We'll schedule you for your next court date. That's going to be a pretrial here at the 15th District Court, January 23rd at 10:30 in the morning. That'll be in person. We'll get you a notice to appear. You're going to receive additional information from the public defender's office. Do you understand?
Can you tell me what day of the week that would be?
January 23rd is a Friday,
Okay,
10:30 in the morning. All right, the next thing we'll need to address in this matter is bond. And there are two parts to bond. Bond conditions, those are things the court tells you you can and cannot do. If you violate a bond condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own or whether you'd have to post a bond in order to be released. Before I make any decisions, I will hear from counsel. We'll start with the people.
Thank you, Your Honor. As I'm sure the court has noted from my bond form, I've not recommended a cash amount in this matter. Defendant appears to have no prior criminal history. I've simply requested the standard no contact, no go-to GPS tether conditions. Thank you.
Thank you. Ms. Anderson.
Thank you, Your Honor. As was stated, my client has no criminal history. The listed complainant is her son. It's my understanding that they do reside together at the address provided. I did speak with her about a no contact and no go to. It's my understanding that she doesn't have anywhere else to go should the court order that she leave the premises. So given that and the fact that it is her home, we would ask that the court allow consensual contact between the parties so that she may return home. She does have full-time employment as a hairstylist and would ask the court for a personal bond.
Ms. Anderson, it's his home too, correct? Isn't that where he lives?
They reside together, but I believe that it's her home and he lives with her. But I'd ask for her to clarify. I see her hand is raised.
Ms. Ross?
yes, Your Honor, he is not technically on the lease, but my son has mental illness and it's pretty severe. And I don't even know what would happen to him if he couldn't live with me. He is on Social Security disability, but it's not enough to move out. So, and he's working, but he's my whole life. Like, I'm a single mom. I always have been, and I live for him. So I can't imagine. I was just gone for 3 weeks, dog sitting for one of my clients, and I just returned home Monday night. So
I'm going to have you stop for a second. Counsel, just one moment. We're having a technical issue. We are still on the record on AAPD 25-65882. The court was just about to issue bond conditions and set bond in this case. Ms. Ross, your bond conditions will be as follows. You are not to use, purchase, or possess any alcohol, any illegal drugs, or any marijuana. Do you understand?
yes,
These are not in the order of importance, just the order listed on the form I'm going to read from, and you'll get a copy of this when we are done. You are not to leave the state of Michigan without prior permission of the court. You're not to purchase or possess any firearms, any ammunition, or any dangerous weapons. Do you understand?
yes,
Do you own any firearms or dangerous weapons?
no,
You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. Do you understand?
yes,
You are, until further order of the court, to have no contact with Najee. When I say no contact, no direct or indirect contact with that individual in person or through others, no telephone, email, texting, internet, or social media. You are not to go to.
I don't know how that, ma'am, I don't know how that would be possible. We live in an 800 square foot home.
Yeah, you're not going back to the house. You're going to have to find somewhere else to stay until further order of the court.
I don't have anywhere else to stay. My father lives in California.
Well, you'll have to find a friend or a neighbor, or a hotel. You are not to go to the address on Platte Road. You're not to go to any home, temporary residence, work, school, or house of worship of Najee until further order of the court. If you need to go back to that address to get some belongings, you're welcome to do that with the civil standby. You would contact the Ann Arbor Police Department and make an appointment to do that. Don't just go. And that's that's not an opportunity for you to stay and hang out. That's not an opportunity for you to communicate with Najee. That's just an opportunity for you to get your things and go. You are not to violate any criminal law. You're required to appear for all of your court hearings and other places as directed by the court. Your conditions, they will exist whether you're in custody or out of custody. They remain in full force and effect until changed by the court. And if there's any change in your address, email, or telephone number, you must notify the court. Do you understand?
Yes.
Any questions for me? I'm going to release you on your own personal recognizance. You won't have to post a bond. There'll be a backup cash bond of $5,000. Ms. Anderson, anything further?
No, Your Honor. Thank you.
And Ms. Rosniewski, anything?
No, thank you.
All right, we're going to get your paperwork over to you at the jail. And if you have any questions going forward, you'll want to get in touch with the public defender. Again, remember, don't just go to that address. If you want to go to get your things, you will have to contact the police department and go when they take you or when they meet you there. Thank you.
I have a question about, am I going to be responsible for the rent there? Since I can't live there?
I don't handle those things. That's not my responsibility to set those conditions.
Oh my God.
So I believe, my guess is you would be responsible for the rent because you are on the lease. You said you were on the lease. So from a legal standpoint, I believe you're responsible. And you'll be back to court on January 23rd. Any other questions for me?
No.
All right, you can stand up and go to the door. We'll get your paperwork to you as soon as we can. Thank you.
Okay, well, let's go on the record. This is in the District Court of Butler County, Kansas. Case is entitled James Reeves doing business as JMR Cattle Company and Timothy J. Smith plaintiffs versus Stephanie Devine and Michael Devine defendants. It's case number 25 CV 307. Would counsel announce appearances, please?
Thank you, Your Honor. May it please the court, Quentin Aker appears on behalf of Mr. James Reeves, doing business as JMR Cattle Co., and Mr. Timothy Smith, who are both present with me in my office, appearing by Zoom.
Your Honor, Jerry Bogle on behalf of the defendants, Michael and Stephanie Devine, both of whom are present.
All right, thank you, counsel. We are scheduled today for hearing on plaintiff's motion for temporary restraining order. Have the parties been able to reach any agreements, or do we need to proceed with the motion?
Your Honor, I was unaware that Mr. and Mrs. Devine had retained Mr. Bogle. I haven't seen a notice of appearance filed or anything in the matter. I believe, in my opinion, Your Honor, our position is relatively straightforward, although some things have changed factually since the filing of this motion a few weeks ago. So I do believe we probably could come to an easy agreement. I just haven't had the opportunity to do that. I didn't reach out directly to Mr. or Mrs. Devine, and I haven't spoken with Mr. Bogle. So I don't know if the court would be interested in giving us a chance to speak briefly off record, or naturally I'm prepared to proceed, Your Honor, today.
All right, Mr. Bogle, I'm assuming you'll be filing an entry of appearance.
Your Honor, I believe I have. I've been
Okay.
told that I have.
Okay, well, it's probably floating in the netherworlds of the e-filing system and hasn't made its way here yet. But if you all think a going into a breakout room and having a discussion may result in some agreement, I'd be more than happy to give you all that opportunity. Mr. Bogle, is that something you might be interested in doing?
Well, I don't know the position of the plaintiff, so I don't have the ability to give an opinion.
Okay, well, do you have any objection to going into a breakout room
I do not.
to see where you're at? Okay. Angela will set out a breakout room and then you two can visit privately. And I'll be here waiting for when you conclude your conversation.
Thank you, Judge. Okay, sorry, Judge.
All right, we'll go back on the record. Same appearances as before. We took a brief recess to allow the parties to go into a breakout room to see if any agreements could be reached regarding this motion. Counsel, were you able to reach any agreements?
No, Your Honor, none that we can reduce to an agreed order at this time. I think we were close on some stuff, but I think we're opting for just a judicial order at this point.
All right, well, then we'll proceed on the motion for temporary restraining order. Mr. Aker, if you'd like to proceed.
Thank you, Your Honor. I haven't appeared in front of you, Judge, in this capacity as it relates to this type of motion. I am obviously willing and able and prepared to sort of just go through the whole thing from the facts, the legal argument and everything and what we want. But I didn't know if there was something that the court sort of just was ready to jump into, or if the court had any specific questions or anything it wanted me to sort of focus on first to expedite things.
I've read through the petition and the motion, so I have a general idea of what the overall situation is. If you'd like to kind of narrow it down as to what you're asking for and why, I think that'd be a good way to do it.
Perfect. Thank you, Your Honor. I appreciate that. I'm largely going to skip then any factual background, as the facts are in the verified petition that was previously filed and reviewed by the court. So the two big issues here that are subject of this motion is, first, that we want to just ensure that we will have access to the property and that nothing will be done to impede or preclude my clients from both accessing the property and otherwise performing under the lease. Factually, in the petition and as incorporated into my motion, when this came to light, the property had been locked. Once ownership had changed, my clients tried to access the property. That's when it came to their attention that the property had been locked and they were unable to access it. So we sought relief from this court. Since then, that has changed, Your Honor, and the Mr. and Mrs. Devine have indeed removed those locks. So there is no active impediment, admittedly, for my clients to access the property, but just sort of based on the history of the things and sort of the number of issues that are contested here, I thought it'd be prophylactic and would behoove all of us at this juncture to just have a written order from the court preserving the status quo that just is very clear in writing that while this case is pending and while we're sorting these issues out, cannot be any additional lockouts or any actions taken by any party, my clients, the defendants in this case, to, again, preclude or otherwise create an impediment to access for my clients. I'm more than willing to go into more detail to that, Your Honor, and sort of speak to the potential damages that my clients will suffer should another lockout occur or should there be anything of that nature that would preclude access to the property. But I'm more than happy to circle back to that. But sort of the other large point of this is that under the lease, the payments are split into 2 annual payments, with one being due January 1. That is tomorrow, as we all know, which is the motivating reason for getting this hearing set in 2025 before the new year came. So based on the lease, the total lease value annually is about, I think, $17,500. And so half of the rent payment is a little over $8,000. I don't want, while this case is pending, we need clarity about where that money is going. When Mr. Bogle and I were discussing this in the breakout room, we very quickly realized that there were some disputed material facts as it relates to where that money is going, which only, in my opinion, underscores the need for the relief I'm requesting, which is that the court hold that money that's due tomorrow, either in its account or in my firm's trust account or in Mr. Bogle's trust account. I don't have a preference for where the money goes, but I do think it would behoove the parties to ensure that everyone can perform under the lease and make the payment that's required to be made tomorrow, but that depending on who ultimately prevails or how this case is settled, I don't want to put my clients in a position, or Mr. Bogle's clients for that matter, in a position where people are trying to claw back those funds or otherwise on the hook for an amount that could be avoided if the funds are protected.
Who's paying who the 8,000?
So historically, Judge, the rent payments have gone from Mr. Reeves doing business as his cattle company to my client, Mr. Smith, to Tim Smith. That's historically where those payments have gone. Again, when Mr. Bogle and I spoke in the breakout room a few minutes ago, it came to light that there are some disputes about sort of the intentions of grandmother Smith as it relates to who retained that money. But historically speaking, the practice has been between Mr. Reeves, grandmother Smith, and my client, Mr. Smith, that the money goes from Mr. Reeves to Mr. Smith. That's how it's been. That is our position as it relates to the interpretation of the lease. And so obviously I'm more than happy, to make sure that gets made tomorrow, but I just think it makes sense to make sure those funds, especially now that they are contested, to make sure they're protected. So those are sort of just the two high level pieces of that. Again, I'm more than happy to go into or to speak to, I think some of the loss or damage that my clients would incur if there's any issues with accessing the property. But I also think, this court, I believe is sort of aware of cattle practices and sort of what goes into making sure, cattle are transported correctly and are being grazed correctly and have all the things they need and that the property is upkept. So I won't belabor that point unless the court needs me to, but those are just sort of the two items that I would like as a result of this hearing.
All right. So your clients didn't have access to the property when it was gated or locked by the defendants. How long of a time period was it before the lock was removed?
I also, when speaking with Mr. Bogle before this, I also learned that that is also a disputed fact. My understanding on that is that, and this is based on Mr. Bogle, what he represented to me. So Mr. Bogle, please, chime in if I'm misrepresenting anything we just discussed. But my understanding is that once the lock was placed, there was a phone call between Mr. Smith, my client, and Mr. Devine about the lock on the gate. I think the contents of that call are somewhat disputed. I think the defense position is that that lock was removed very shortly thereafter. I believe that same day. That's not our position. After that phone call, my client went out to the property the next day and it was still there. It was still locked. Since then, though, in preparation for this hearing, my clients went by the property again, and that's when they told me that the locks had been removed. My clients don't
your
live at
clients
this.
have access to the property to engage in their cattle operation currently?
The first part of the question, Judge, I'm sorry, I was speaking over you, but I believe the question is, do my clients now have access?
They have access now and can engage in the cattle operation they had been engaging in?
Yes, my understanding is all the locks are off and there are no additional active impediments to my clients accessing the property.
Okay. All right, Mr. Bogle, let me address you. So of these two proposals, which I understand to be the access to the property, not to be impeded, and the holding in trust of the $8,000 that's due tomorrow, what is your client's position regarding those proposals?
Your Honor,
The temporary orders.
our position is that in November, let me back up. The Billy died in April, Grandma Smith, and there was my clients do not live, they live about 30 miles from there, so they don't go by regularly. Nevertheless, in November, they heard that someone had been injured on the property, a third party, and they thought they should put up a no trespassing sign. They put up a no trespassing sign. They put a lock on the on a chain, and by the time Mr. Devine Michael returned home, he received a call from Timothy, and Timothy was angry. He had seen that somebody had put a lock on it. Mr. Devine says, "Oh, those are combination locks. I'll give you the combination right now." He says, "I don't want the combination. I'm going to go cut them off." So we have a cousin living in the area. They reported the next day that someone had cut the lock off the gate. So if they had any, they didn't have any time when they didn't have access. It wasn't to keep them off the property. It was to advise trespassers that they weren't permitted on the property, and to let Tim and I guess he's an agent for Mr. Reeves. That'll be an issue in the hearing, whether he's working for Billy, the grandmother, or whether he's working for Mr. Reeves, because he was calling Mr. Devine on behalf of Mr. Reeves, I guess, although I don't know whether Mr. Reeves knew there had been a lock put on the gate or not. In any event, our position is they were never denied access. We're not interested in the court making an order as if we had denied access. I've agreed with counsel that I would send a letter over saying until this matter is over, we don't intend to change our position. We haven't denied access, and we're not interested in agreeing to an order to that effect. Number two, as to the money that was being paid, we are aware that Mr. Reeves was paying money to Mr. Smith, Tim Smith, for a few years prior to this year, and that Grandma Smith was acquiescing in the gift from her to him. Nevertheless, we also are of the position that Billy Smith told Mr. Reeves, stop paying that money to Tim. I want you to pay the money to him, to me. But even if she didn't have that conversation, from the time that Billy died, the estate owned that property or owned the right to that contract. And if anybody should get the money, it should be Billy Smith's estate.
Is there a probate case opened?
There is, Your Honor, but it's not handled by my office. May I make a couple of other comments?
You may.
Your Honor, they're looking for a temporary restraining order, and we think they've asked that bond be waived. Our position generally is, and this is general, but that property has a value of in the neighborhood of $1 million. And if my clients were to sell that property, they would have the ability to get maybe 5 or 6% off of $50,000 or $60,000 a year. So the petitioners have created a cloud on the title, and it has value, and we think they should be bonded to the extent of $150,000. They also haven't shown any immediate and irreparable injury. That's another issue that we're involved in. These are not to be off-the-cuff impairments on property titles. If there's an immediate and irreparable damage, then you're entitled to it. And the case law would indicate that if the damage can be repaired by the payment of money, it is not immediate and irreparable.
All right, anything else in that regard, Mr. Bogle?
Well, we have other problems here, Your Honor, and that is we believe that the joinder that is current by the two plaintiffs under KSA 6220 is inappropriate. It's not proper because the issues of fact and the issues of law are not coexistent between the parties. It is not a case that would cause a benefit to have the parties be joined. And related to that is KSA, Rules of Civil Procedure or Professional Conduct 1.7a, conflict of interest. What we have here is interesting in that we have Mr. Reeves wanting to find Billy competent in September of 2024, and we have Tim Smith wanting to find her incompetent in December 2024. There's a conflict between the two parties. It is a serious, irrefutable conflict, and we're asking that the parties be severed, and it's a combination of 6220 that not joined, and number two, a conflict of interest 1.7a of the Rules of Professional Conduct. So we think this case doesn't allow this to happen. And once we get these parties severed, and you also have the situation where it's not just a matter of refiling another case by the same attorneys, because the attorneys for the plaintiff have this conflict of interest. And to the extent that the parties are severed, that Mr. Reeves needs an independent attorney.
All right, but that's not an issue that's currently before the court today, is it?
Well, it's not, except that what we have here is a dispute concerning the access to the property, and when in our opinion the parties are inappropriate. You shouldn't have these two men as joined plaintiffs in this case, and we're making decisions regarding one of them.
What court has the probate case?
Butler County.
All right.
I think Judge Ricke has the case.
Okay. All right. Mr. Aker, any response based on Mr. Vogel's statements?
Yes, Your Honor, a few things. I mean, the court already hinted at this, but naturally, whether there's some issue with joinder and whether, defense is taking a position that there needs to be some form of severance here and that there's some alleged conflict, none of that is properly before this court, as the court already noted. And then to the extent there's a conflict of interest or not, that is an issue that the disciplinarian is empowered to decide. And again, that's not properly before this court. So to the extent, the court is inclined to make comments or rule on that, I would just say those are very inappropriate for an oral motion to be made at the outset.
I'm not asking the court to rule on that. I'm telling him that this is too early to make decisions regarding a temporary restraining order. I'm not asking for a ruling.
All right, understood, Mr. Vogel.
Okay, thank you. There was also a representation that, again, there's factual dispute as it relates to the logs. One of the concerns that was outlined was that, the defense didn't want to be in a situation where an order was entered that would give the impression that there had been any wrongdoing done by the defendants. I understand, again, factually that the lock is now off, but again, I think prophylactically, it's still in our best interest to just ensure that nothing like this happens in the future. Whether or not there was some threat of a third-party trespasser or someone getting injured, this is the first I'm hearing of it. I'm not aware of anything related to that back from November of 2024. But the issue with the irreparable harm is that this, in the cattle business, Your Honor, nothing is quantifiable. There are no hard dates that we can put on calendars. I can't represent to the court that my client needs access to the property on March 1st, or we're going to suffer irreparable harm on that date. That uncertainty is baked into the industry. Mr. Reeves has been in this industry for quite some time. He routinely gets calls that he is to receive a number of heads of cattle the day before, and he is expected to be able to put them somewhere. So with this type of uncertainty, should there be another lockout or something, we don't have time necessarily to run back to the court and then at that point seek an order permitting us to go back on the property so that Mr. Reeves at that point then can suffer damages that could otherwise be compensated financially. So to the extent that, the defense position is that this type of relief is inappropriate because it can just be remedied by money, that's not really available or realistic in this type of industry. There's uncertainty about how many cattle will actually come. There's uncertainty about the transportation up from other states, up from Texas. Just with the number of uncertainties, again, that's what makes this case unique and sort of shifts the sort of immediate and irreparable harm analysis. So again, I know the lock is now gone, but because in the future there will be irreparable harm that isn't going to be quantifiable, I still think it's appropriate for the court to enter that order now. And as for any argument about the valuation of the property or anything, I think we're putting the cart before the horse. I think boiled down, we have a lease. Mr. Bogle has brought up some agency arguments. Again, I think these are red herrings. The issue in front of the court is that there's a rent payment that needs to be paid tomorrow, regardless of who ultimately the court finds that money needs to go to. I think it needs to be protected. This doesn't prejudice my clients. It doesn't prejudice Mr. Bogle's clients. And so I think to make sure that there isn't some, future issue with that, I think that the court should rule today that that money be held in trust until a determination can be made. And so along with those lines and sort of the immediate harm or irreparable injury analysis, that also supports our position that security in this needs to be waived. The value of the property at issue, that's not what this case is about. I don't know. I'm not fully up to speed on what's happening on the probate side, Your Honor. But on this side, we're talking about $8,700. So, regardless of the large property valuation and certain financials that can flow from that in the future, now the narrow issue is the payment due tomorrow, as it's contested, should be protected to avoid harm in the future. So those are the things we're asking for today, Judge.
All right. There's a lot of issues that have been brought up here today that obviously are going to need to be sorted out. For purposes of today, though, I think it is appropriate for an order to be entered to allow the plaintiffs to have the same access to the property that they've had, basically to preserve the status quo. I'm not making any factual determination that the defendants were trying to prevent them from coming in or that was the case. I'm simply entering an order that the plaintiffs be able to run their cattle operation as they have been under the lease, so to speak. Again, I'm not determining that anybody's at fault or that anybody did anything wrong. That I think for a temporary order while these matters are pending, that's appropriate. I also think it's appropriate for the $8,000 that's due tomorrow to be held in trust. And Mr. Bogle, if your office is willing to hold that money in your firm trust account.
We will, Your Honor.
Okay. I think that would be an appropriate order. to enter as a temporary order pending the litigation in this case. I'm not going to make any ruling on a bond at this time. I'm simply offering or ordering the two requests for relief that I've just gone over. If there's other motions that need to come before the court regarding joinder and bond and that sort of thing, we can certainly take those up once the appropriate motions have been filed. Perhaps the parties can work some of this out, short of extensive litigation. I know today was the first opportunity that the parties have discussed ways to resolve these issues, but just for the sole purposes of the temporary relief that's been requested, that's the order of the court. Mr. Aker, I'm going to ask that you prepare the appropriate journal entry that memorializes those orders. I assume that discovery is going to be occurring and that sort of thing. Counsel, do we need to do some sort of a scheduling order? Do you all think that's something that you can work out, or is it too premature at this point to?
No, I think we do need a scheduling order, but I've continued the time to answer for 14 days, so we haven't even filed an answer. I would like to leave that in abeyance until I speak with Quentin about it and see if we can present an order to Your Honor.
And I'm confident Mr. Bogle and I can put a scheduling order together without issue, Your Honor.
All right. Well, I'll leave that in you all's capable hands. If we need to get a date set, just coordinate that with Miss Cool, and we can get it calendared if we need to take up any motions or anything else regarding the case.
And Your Honor, due to the sort of time-sensitive nature of this, it's 3:50. Obviously, I know Mr. Bogle is in his office, so if I'm able to draft the order and submit it to Mr. Bogle for his approval, and then if we file it today, do you think the court would be able to get that through the queue today, or should we just operate under the assumption that the court's order is in effect now upon the oral ruling, and then just get the money to Mr. Bogle's trust account after the first of the year? What's your preference?
I can't guarantee that it will make its way through the electronic maze this afternoon, assuming you get it filed in the next hour. I think, I don't know if the clerk's office is fully staffed right now since it's New Year's Eve.
Okay.
So I think the court, I will certainly look at it. I obviously won't be in tomorrow as it's a court holiday, but I'll be working Friday, perhaps remotely, but I'll have access to my queue and email and anything I need to do to run my business. So.
All right. Well, Judge, I will endeavor to get that done today, with the understanding, regardless, that Mr. Bogle, the money will be headed your way.
I'll be here on Friday.
Okay.
All right, Mr. Bogle, anything else from your perspective?
Nothing, Your Honor. Thank you.
All right. Have a happy new year, everyone. If there's nothing further, we'll be in recess.
Thank you, Your Honor. You as well.
Thank you.
Thanks, Quentin.
Thanks, Jerry.
And Your Honor.
Yes, Mr. Ricke.
Your Honor, if the court will go on the record in Davis, I believe I can advise the court as to the current status of the matter.
Without the need for Mr. Patterson?
That would be the state's understanding, Your Honor.
Okay, very good. Then we could do that. Go ahead and bring in Mr. Davis, if you don't mind.
Okay, we're getting you now.
And we are going to go on the record in State of Kansas versus Jacob Davis, case 2024 TR 2014. Judge Webster.
Hi. Did I get replaced? Apparently, I did not know I had a pro temp today.
Well, my understanding is that you were not available, so they had me do it. But I am happy to defer to you this morning. Are you available all day, or is it just this morning?
Yeah, I didn't know that they had gotten a pro tem, so. And Missy and I are kind of surprised, but you're doing a fine job from what I can hear. But You have other things to do that you'd rather do?
Yeah, I've always got stuff I could do. So, Your Honor, I will happily turn matters over to you.
All right, which ones have you completed, if any have been completed?
None have been completed. We were just announcing Jacob Davis. Mr. Ricke was going to be able to make an announcement on that.
All right. Well, thank you so much, Mr. Andrews, and I'll pick it up from here.
Thank you, Your Honor.
You're welcome. We are on the record in BU 2024 TR 2014, State of Kansas versus Jacob Robert Lloyd Davis. And we have Jared Ricke for the state. I understand Darren Patterson is here for the defendant who appears in person at security. Is that all correct?
I don't believe Mr. Patterson's here.
He just joined us.
Oh, he just joined. Okay.
I am present, but not on that case.
And Your
Okay.
Honor, the state would be, if the court is on the record in this matter, the state would request a point of clarification.
The court is on the record, and I do show Darren Patterson as attorney of record, but it could be he was appointed and not given the appointment. So is that the point of clarification you're seeking, Mr. Ricke?
Your Honor, the state's information is that prior to today's setting, a request for revocation was filed with the court, followed by an appearance bond executed in the amount of $2,500 for today's date and time. Prior to that, it would appear an order appointing counsel with respect to Mr. Patterson was filed with the court in March of this year, to be followed by a subsequent journal entry of misdemeanor conviction and sentencing from a May 2025 hearing filed with the court in June of this year. So the state would be requesting clarification as to whether or not Counsel Patterson has any continuing obligations in this matter.
Well, let me look through. There's been a lot of activity on here, so I'll need to look.
And Your Honor, if I may,
Yes, Mr. Patterson.
generally on those, this would be a first appearance on the warrant to show cause, and they would have to requalify for court-appointed counsel for the court to take up that issue and reappoint if necessary.
Well, I show a September 19th, 2025 bench warrant to show cause filed. Curiously, filed right before that was the request for revocation probation went hand in glove with that. And I do not see that the defendant has appeared since that date, so
And Your Honor, the state's information is this is the first hearing subsequent to the hearing back in May where a plea was entered and the matter proceeded to sentencing.
Yes, so, okay, Mr. Davis, you're there with court security, is that right?
Yes.
Okay, you are here because the state is alleging that you violated the probation you were granted on May 12th of 2025. On that date in May, you did plead guilty to counts 1 and 4. The state dismissed remaining charges. You were sentenced on count 1 for $108 court costs and a $45 fine. On count 4, a $100 fine. You were given a 6-month underlying on count 4 with a 1-year probation to include a $60 supervision fee, 10 days house arrest with work release, and $250 attorney fees due in 60 days. Your house arrest was to begin within 14 days of your sentencing and granting a probation. That'd be within 14 days of May 12th.
Yeah, I did complete that 10 days house arrest.
Okay, at that time, your court-appointed attorney was Darren Patterson. But as you've heard from the attorneys, if you're going to have an attorney representation, that you'll have to either hire one. If you cannot afford to hire one, apply for court-appointed and qualify, or you can waive your right to an attorney and represent yourself. However, when probation is revoked, there is the probability of serving a sentence. So what are you going to do on these allegations concerning an attorney?
Oh, yes, I would like to. And at that time, I did not understand the terms and conditions of my probation.
Well, we're not going to get into that just right now. The first order of business is you want to apply for a court appointed or you want to hire?
Apply for a court appointed.
All right. Where do you work, Mr. Davis?
Dollar Tree. I'm an assistant manager.
What do you get paid per month?
Yeah. Hourly, I get paid $11.50. About 500 per month.
500 per month. Married or single?
Single.
Do you live with anyone who helps pay your bills?
No.
Okay. Do you have any minor children you legally support?
Yes.
How many?
2.
Do those children live with you?
Yes.
The mother of the children does not live with you?
Yes, she does, where it's not filed as married.
But she doesn't help with the bills, or does she?
She does.
Okay, I asked you a while ago if you lived with anyone that helped with the bills, and you said no.
I'm sorry, I didn't understand. I thought you meant single, married, or whatnot. But no, I live with my wife. We live together.
And she does have a job outside the home?
Yes.
Where does she work?
Celebrity Cruises.
And what does she make per month?
1,000 per.
Okay, so she makes 1,000 per month. You make 500 for combined income of 1,500 a month. Is that correct?
Yes.
And then between the two of you, what do you pay for rent or a mortgage payment?
About $1,500 a month in rent. And that doesn't include gas, utilities.
Who pays for those? Because you've just told me that's the same as your combined income. So what's your utilities come to?
It differs really month per month.
I understand, but the average payment would be what?
About $460.
Okay, and any other expenses?
Besides childcare or anything the children need.
Yes, if you have to pay it, how much is your monthly child care?
Probably about over $350, $375.
Well, you're telling me that you're spending more than you're taking in, so who's paying that for you?
Sometimes we get help from family. Mother, grandmother.
All right. Well, I want you to get an application, a written one, and fill out the written application before you leave. I am appointing Attorney Darren Patterson. Go to his office today, give his office staff your contact information, and be ready to go at the next hearing, which will be when, Clerk Jenna?
Your Honor, Monday morning would be March 16th at 9 a.m.
That's March 16th at 9 a.m. That's the earliest we can do.
Let me double check the misdemeanor control calendar.
Okay.
And Your Honor,
Mr. Ricke?
it would appear that Court Services Officer Smith is present on the Zoom conference. Whatever date the court does determine to be appropriate, the state would respectfully request the court inquire as to his availability, as he will likely be, his presence will be likely required in the event this case does proceed to evidentiary hearing.
Yes, thank you, Mr. Ricke. Mr. Smith, does that date work for you? March 16th at 9?
Yes, it does, Your Honor. Thank you.
You're welcome.
And Your Honor, I looked into it. March 16th is our soonest. We're full up until then or over.
I'm sorry, say that again. It's spilling over too many other?
Every day up to March 16th, we're hitting the max or we're over the max amount.
Well, Mr. Smith, would you want to continue to see him on probation till March 16th, even though he hasn't allegedly been doing what he was supposed to?
Yes, Your Honor. I actually supervise him on another case that he picked up while he was on probation in this case. So I'm seeing him, and I would ask that he report to my office following today's hearing.
All right. This matter will be continued to March 16th at 9 a.m. Now, Mr. Davis, common sense would tell you that That's quite a bit of time. So you can either really bury yourself on probation and lose it, or you can turn this all around and maybe get a different outcome.
Okay, I think I have to turn it all around. I have a job. I've paid on my fines.
Don't go into that now. We'll address that when the time comes and your attorney's.
I've been doing everything the court's asked me to do, so I don't understand that comment.
From me?
Yeah.
Well,
I've gotten a job.
Oh, okay, sir, stop. What I have is a document saying when it was filed, you weren't doing everything you were supposed to.
Yeah, but now I am.
Okay, well, we'll find out when we have a hearing. But why I made that comment is because the allegations are that you haven't been doing everything. And if you haven't, then this will give you a chance to
turn
it around. That's what that comment meant.
I think the probation officer, I need a transfer because it's been, I've been doing everything that I've been supposed to be doing, and he acts like I'm a felon, and I'm not. And it's been getting kind of, tit for tat with him, and I don't like it. How he's been treating me, I've been more respectful to him, and he's just been, belittling, talking down to me, and I don't appreciate that. That's not what he's there for, and that's not what I'm here for. I'm here to be bettered, correct? That's not happening. He's just making me feel lesser than. And it seems like ever since I gotten a job, he's been out to get me. So that'll be it, Your Honor.
I see no need to change Mr. Smith as your probation officer. He's always, to this court's knowledge, done a fine job. And basically, you're the one on probation. He's not.
Yeah, and I'm not here to be belittled and talked down to every time I come in here.
Well, you're not here to have your hand held and praised.
I'm not asking for that. I'm not belittling. I'm not here for that, Your Honor. I'm sorry. It is every probation meeting I go to. It is belittling, talking down to, you make $11.50 an hour. That kind of sucks. I'm not here to hear that. Okay, I've gotten a job.
All right,
I've paid on my fines.
Mr. Davis, stop right there.
So I'm not here for that.
Listen to me. Ryan Smith is a court service officer. He's here to serve the court.
Exactly.
And when you start telling me that he's not doing his job right, that's coming back to the court as well. Now, you talk to your attorney that the citizens are going to pay for you, and you talk to that attorney, and that attorney will explain to you in more detail the importance of Ryan Smith's job and the importance of you respecting what he's telling you. Now,
I do respect what he's telling me.
He's not going to be handling you with soft gloves if you're not reporting when you're supposed to, if you're not paying like you're supposed to, if you're not doing what you're supposed to. He is going to be a lot tougher with you. I don't know what you've done or not done, and that's what the next hearing will be about.
Okay. But don't treat me ever like Tom, Dick, and Harry that he sees, because I'm not that person. So this is my first time ever being through this, ever, on probation, and my terms and conditions weren't explained correctly to me. He kind of, pulled the wool over my eyes on my first, drug testing me, and that wasn't supposed to happen. He's supposed to send me to a drug evaluation before he even drug tested me. That didn't happen.
Where'd you get your law degree?
That's just what I was explained to by Seventh Direction.
Where'd they get, who Seventh Directions is a lawyer there?
Seventh Direction, it is a drug evaluation.
Yeah, they're an alcohol and drug evaluation, but you're telling me they're giving you legal advice. Who's their lawyer? I didn't realize they had an in-house.
I don't know who their lawyer is, but that's just their advice. That's what the clinical director told me.
The clinical director of Seventh Directions.
Yes, ma'am.
Well, and you don't know that person's name?
Clara Vineyard was her name.
I'll tell you what, when you come before me, you don't bring me legal advice and tell me or the court service officer how to do our jobs.
I'm not trying to tell you how to do your job, Your Honor. It's just that I know.
You are.
No.
Okay. Yes, you are. You're telling me that he was supposed to do this and he was supposed to do that because someone told you that. You listen to your lawyer, you listen to your probation officer, you listen to the court. If you want to succeed in this case, that's what you do. You don't go out and start asking people for other legal advice or taking it when it's volunteered. Mr. Smith knows how to do his job. I know he does. He's been around here too long. As far as this Clara, I don't know, but I know unless she's a lawyer, she shouldn't be giving out legal advice. She can do fine on alcohol and drug evaluation if that's her thing that she does.
Yes, Your Honor.
But don't go in there arguing with Mr. Smith because he's the boss.
I've never argued with him.
Well,
I'm just an advocate for myself.
And this lawyer that never explained things to you that you're complaining about, was that Darren Patterson?
Yeah, yeah.
So you had an attorney that didn't explain things to you, and then you had a court service officer that explained things wrong to you and asked you to do things you shouldn't do. Is that right?
It didn't clarify. You know, I understand that this is all my fault as to why I'm here. I'm not putting the blame on anyone else. But I've never been on probation before in my life. And, you know, it feels like they try to dig you deeper and dig you deeper. And, I got you moment. I wasn't explained everything. You know, you're going to have to talk to me like I'm stupid in this whole probation area because this is all new to me.
Now, you told me that's what they were doing when we started this and that they shouldn't be talking so simply to you.
Well, I guess so.
You said they were talking to you like every other time.
I go in there and he has an ego. So, you know, not talking stupid, belittling, you know.
Okay, so he was belittling you, but he needs to talk to you like you're stupid so you understand. Is that what you're telling me?
Yeah.
Maybe you don't need or want probation. Maybe maybe I can just revoke your probation. We'll talk about that at the next hearing. Maybe we can just revoke it and you won't have to just deal with the probation officer.
And that'll jeopardize my job.
Well, I don't go out looking for people.
Wasn't that one of my terms and conditions of my probation is that I needed to have a job?
Sir, I'm not here to debate with you. I've given you an attorney. You better, if you know
Darren
what
Patterson, correct?
Yes.
Okay.
And a lot of people would love to have Darren Patterson for their lawyer. So I don't know why you're having troubles with him and why you're having trouble with Ryan Smith. They're both very competent, experienced attorneys. From my experience, and I've worked with both of them for many, many years. At this time, I'm going to set your court date, your show cause date, if we haven't already. Jenna, when is that?
Your Honor, that's March 16th at 9 a.m.
March 16th at 9 a.m. You must be back. You're live in person at the courthouse. Don't show up by Zoom. That's a non-appearance. You're live in person, March 16th at 9 a.m. And I'm going to order that today you walk across the parking lot to Mr. Patterson's office and give all your contact information to his staff so they can get a hold of you. But if they don't call you, it's not their fault. You're the one who has your liberty on the line, not them. You call them if you don't hear from them.
Okay.
I know they go out of their way trying to get a hold of clients, but it's not their responsibility to chase you down. So,
Pardon me, Judge.
Yes, Mr. Patterson.
I just could, if I could, give him some different direction. My staff is gone for the day for New Year's Eve. So I just want to make sure he calls on Friday morning so that they can get all his contact information.
All right, let's see. It looks like August 1st, 2025, you posted a surety bond with Second Chance. I'm going to continue that bond with added conditions that you do as Mr. Patterson just said, contact his office Friday.
Friday, okay.
As he said, you said Friday the 2nd, right, Mr. Patterson?
Yes, Your Honor.
And did you give him a specific time?
He just needs to call the staff Friday morning. They'll take his intake and then we'll contact him after that.
All right. And again, if he doesn't, I expect you to contact him.
Yes, sir.
All right. I'm talking to him, not you, Mr. Patterson. I'm saying if you get too busy, Mr. Patterson, with other clients' obligations, it's Mr. Davis that must call you again. All right. And I'm adding a condition that you reappear in court, Mr. Davis, live in person, March 16th at 9 a.m.
Okay.
And that after court, Mr. Smith, you want him to go back to see you, is that right?
Yes, I do, Your Honor. And just for a point of clarification, should he be present at 9 or at 8 o'clock for that hearing?
Well, Mr. Patterson, what do you
8
have?
o'clock, Your Honor.
8 o'clock. All right, you must be back here March 16th at 8 a.m. live in person. And you must go see Mr. Smith down the hall before you leave today. And between now and March 16th, you are still on probation.
Yes.
He is still the boss. Even if you don't like the way he talks to you, he's still the boss of probation.
Yes,
and he's
ma'am.
still going to make recommendations come March 16th. So with that being said, Mr. Davis, unless there's anything else, Mr. Ricke,
Not from the state, Your Honor.
Mr. Patterson, anything further?
Nothing further, Judge.
All right, then, Mr. Davis, you are excused from today's proceedings with the conditions on bond that I've given you. You may go at this time.
Thank you, Your Honor.
You're welcome.
All right, we'll go on the record in State of Kansas versus Shaku, McCory, case number 25 TR 176. The state appears by Darren Devine. Mr. McCory appears in custody from the Butler County Jail. All right, Mr. McCory, it looks like you failed to appear October 29th in front of Judge Webster. A bench warrant bond forfeiture was issued and she ordered you to be held without bond. I'm going to set this over on the expedited misdemeanor control docket this Friday, January the 2nd at 1:30 in front of Judge Lee. Are you going to have an attorney or wish to have an attorney represent you, Mr. McCory?
I mean, if I need to, yes, sir.
Okay, well, that's up to you. An attorney might help figure out what kind of options you have.
Yes, I like attorney.
Can you afford to hire your own attorney?
Not at this moment.
Okay, are you employed?
What's that?
Are you employed?
Yes, I'm employed.
Okay, where do you work?
South Central Mental Health.
All right, what do you do there?
Children's case manager.
All right, I'm going to appoint Darren Patterson to represent you. You may be ordered to pay back some or all of his fees, depending on what happens here. But he'll be present in court with you Friday at 1:30 on that docket. Do you have any questions?
It's just information.
Yeah, it's court date.
No, not at this moment.
Your Honor, if I might make a suggestion, the charge here, I know the defendant was in the process, or at least he discussed applying for diversion. I don't think that was completed. But the charge here is one of driving while suspended first. So I would open up the idea, at least, that if the defendant wanted to waive counsel and just plead as charged, we potentially could have the case taken care of and have him released from the jail if the court's motivated to do so.
Okay, well, I'm okay with that. It depends on what Mr. McCory wants to do. This is a first time driving while suspended charge, Mr. McCory. Are you interested in waiving counsel and entering a plea, or would you rather consult?
I would like to enter a plea. I've been here. I was under an impression that I'd be able to bond out. I've talked to people at the sheriff's department before I turned myself in. So, I mean, at this point, I would like to plead.
Okay. When did you?
Because I have a court date over this on the bond issue on the 2nd of March.
All right. Why didn't you appear back on October 29?
Well, had the wrong date. I thought it was the 30th. My kids were sick that day, and I called the courthouse, but obviously I called them too late. That Wednesday, my wife was out of town, so I was home with 2 sick kiddos. So I was unable to appear in person.
All right. Well, if you want to enter a plea without counsel, I just need to explain to you that you are entitled to have an attorney represent you. If you can't afford one, the court will appoint one, as I just did. You understand that? Yeah. And you wish for me to.
So this would be a misdemeanor on my record?
It would. It's a Class B misdemeanor. It carries a maximum penalty of 6 months in jail and up to a $1,000 fine. And while this court won't take any action against your driver's license, the Kansas Department of Revenue most likely will, in form of some sort of a suspension. So those are the possible consequences. You could be placed on probation. That could be reporting, or it could be a non-reporting probation. So those are the possible consequences. So if you want to proceed without counsel and enter a plea, we'd go ahead and have you sentenced today. If you want to consult with an attorney and wait and see what your options are before deciding, we can do that as well.
Am I looking at jail time, really? Possible jail time?
Well, in my experience on a first-time offense, driving while suspended, usually there's no mandatory jail time and none is usually ordered, but it is a possibility. Do you live in El Dorado?
I live in Andover.
Which South Central Mental Health facility do you work at?
It's the one in Andover, but I'm in Augusta. I work here in El Dorado occasionally, depending on which clients I have here.
All right.
So I'm all over. I mean, my main office is Andover just because I live there.
Well, if you want to consult with an attorney, I might consider a modification of that bond and keep you on that Friday docket. But I'll leave that decision up to you. If you want to proceed without counsel and sign a waiver of counsel, we can do that. If you want to go ahead and have the court.
I'll proceed without counsel.
All right. Is there a waiver of counsel form there at the jail?
Yes, Your Honor.
All right. Read through that, Mr. McCory.
My name here, friend. You're gonna read through it. Okay. Right here, sign here, defendant. Yep.
Do you have any questions about the waiver of counsel form you've signed? All right. Is that a no?
Yeah, no questions.
Okay. All right. I've gone over the possible penalties that could be imposed. Mr. McCory, your options, if you're admitting that you did in fact drive on December 10th of 2024 while your license is suspended, you can enter a guilty plea. If you don't wish to admit to that, but are choosing not to contest the charge and accept conviction, then you could enter a no contest plea. Or if you want to proceed with hiring an attorney or consulting with an attorney, you could enter a not guilty plea. Do you understand what your options are?
Yes, sir.
All right. And how do you wish to plead?
There's no contest.
All right. Mr. Devine, can you provide a brief factual basis?
Sure, Your Honor. It looks like on December 10th, 2024, 11:25 a.m., the defendant was driving looks like it was on Highway 54 at milepost 230, which is in Butler County. He was operating a 2012 Chevy Tahoe. and pulled over with a suspended, there was a suspension on his driving record as he was pulled over in that location. Charged with driving while suspended. This is a first offense, misdemeanor by Officer Parker of the Andover Police Department. And I believe those are the elements needed for the court.
All right, Mr. McCory, do you understand that if you're contesting those facts, you'd have the right to have a trial either to a jury or to a judge on these allegations?
Yes.
And do you understand that at trial, the state has the burden to prove your guilt beyond a reasonable doubt on each element of these offenses?
Yes.
And you wish to waive those rights to trial and proceed with a no contest plea and accept conviction?
Yes.
All right. I do find there to be a sufficient factual basis. I do find that Mr. McCory has been advised of the possible penalties and the rights he's giving up by entering this plea of no contest, and I will find you guilty of the sole count of driving while suspended, first offense. Mr. Devine, what recommendation do you make for sentence?
Your Honor, I'd recommend a 6-month non-reporting probation for the defendant, to have a 90-day underlying sentence, $200 fine, and payment of court costs.
All right, Mr. McCory, anything you would like to say as far as recommendations for sentencing or anything else?
So it said 6-month underlying probation?
6 months probation.
6 months probation. What's that? What's that? So no driving offenses, no. Is that what that means?
Well, it means if I accept those recommendations and place you on that probation, you'd be expected not to violate the law.
Yes.
And to pay your costs and fees.
Yes.
Okay. Anything you want to say or any recommendations you would like to make?
You know, I got one thing. I didn't know I was driving on suspended. And when I initially got pulled over, I was pulled over by the deputy. He said I made an improper lane change as the reason for me being pulled over. And then when he ran my information is when he said that my license was suspended. So that's when I found out that it was suspended.
Okay. All right, Mr. McCory, I will follow the recommendation that's been made here and place you on a 6-month non-reporting probation from a 90-day controlling jail sentence, which means you don't have to serve any of those 90 days unless you're brought back before the court with an allegation that you violated your probation. Then you could be looking at serving that time.
6 months.
I'm going to order you pay a $200 fine and pay the court costs of the action. How soon can you get that paid?
The $200?
Plus, Mr. Devine, what's the misdemeanor court cost?
Judge, they've changed so many times I've just forgotten, but it's probably in the vicinity of it's $150 or thereabouts. I don't know if Al can provide some perspective on that.
The traffic is 108.
108.
So a little over $300.
I'll pay that this Friday.
Okay. Well, if you can get that paid, I'll order that be paid within 60 days.
I just go to I come to El Dorado to the courthouse and pay, right?
Right, to the Butler County Judicial Center. Okay. And go into the court clerk's office, and they should have all the appropriate paperwork. I don't know if they'll have all the paperwork by Friday or not. You might call over first before driving over here.
Okay.
So, Mr. Devine, anything else?
No, I have the same concern, which is especially with the New Year's holiday. I don't know if the clerk's office would have everything ready for you, but you have 60 days to pay this off, and so I would call the clerk, just like the judge just said. Call the clerk beforehand, make sure they've got your case on file and it's good to go, and then you can make that payment. In fact, you can make that payment online if you want.
Okay. All right. Thank you.
All right. Just as a condition of probation, get the case paid off and don't violate the law.
All right, thank you, sir.
All right, if you don't have any other holds, they'll be able to release you today.
All right, thank you.
All right, have a good day.
You too.
That's all for the jail, Your Honor.
All right, thank you very much. Happy New Year.
Butler County, Kansas, case entitled State of Kansas versus John Robert Smith, case number 2025 CR 350. Defendant now appears at a court security Zoom location at the Judicial Center. Amber Norris appears for the state of Kansas. Joseph Favre is defense counsel. This matter is scheduled to come before the court at this time for evidentiary preliminary hearing. I trust your client is still seeking an evidentiary hearing in this matter, Mr. Favre?
He actually is not, Your Honor. We've reached a plea agreement he'll be waiving today.
All right. What is the plea agreement, Mr. Favre?
Judge, Mr. Smith, after waiving preliminary hearing, will be entering a plea of guilty to count 1, felony theft. Time of sentencing, state will agree to dismiss count 2. At time of sentencing, defendant will be screened for Senate bill, but recommendation will be low end of the box, and it's possible that a departure motion will be necessary, at which point the state will agree to stand silent on said motion.
All right. Ms. Norris, has Mr. Favre announced consistently with your understanding as to how this case would be handled?
Your Honor, that is correct.
All right. All right, Mr. Smith, it's been announced that you would now waive your preliminary hearing, and rather you would dispose of your case by entering a plea of guilty to count 1 felony theft, a level 9 non-person felony, in return for the state's dismissal of the count 2 misdemeanor charge, as well as certain sentencing concessions or recommendations that they are willing to make. Is that indeed your intention?
Yes, sir.
All right. I've got a number of questions I need to ask you regarding the taking of a plea of guilty. It does appear that there's not going to be an evidentiary hearing today. Any of the witnesses that were subpoenaed to testify at the preliminary hearing can be released at this time. You are certainly welcome to stay on the meeting. If you wish to stay on the meeting, I just ask that you continue to mute yourself as the proceeding goes on. All right, Mr. Smith.
Yes, sir.
All right. I will need you to speak up as you answer the court's questions. I want to make sure that all participants can hear your responses to the court's questions, okay?
Yes, Your Honor.
All right. State your full legal name for the record.
John Robert Smith, common spelling.
Okay, I'm sorry.
John Robert Smith, common spelling.
I didn't hear the last part of it. What is that part?
Common spelling. JOHNSMITH.
Okay. Okay. I think I understand now what you're telling me. How old are you right now?
I'm 26.
What's the highest level of formal education that you've attained?
I graduated
from
Norton High School.
Okay. Do you believe you're going to have difficulty understanding any of the legal questions that the court is going to ask you here today?
I don't believe so.
If there's anything that you have asked of you that you do not understand, I'll give you the opportunity to confer privately with your lawyer at any point. Just let the court know if you need that time to get further advice, okay?
Yes, Your Honor.
All right. Mr. Smith, have you ever been adjudged to be mentally ill?
No.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking any mental health medication that you are not currently taking?
No, sir.
Mr. Smith, as you proceed today, do you believe your mind is clear and that you have a full understanding of what's going on here in court?
Yes, Your Honor.
Did you receive a copy of the original charging document in the case?
I'm sorry?
Did you receive a copy of your original charges in the case?
No, I have not.
Do you understand the nature of the charge of felony theft?
Yes, Your Honor.
Okay. You understand that when you enter a plea of guilty, you are admitting that act that's been charged by the state in count 1?
Yes, sir.
You further understand that when you enter a plea of guilty, you give up any legal defenses that you might have had to that charge?
Yes.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Favre, and that you could present evidence at your trial and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, Mr. Smith, you would have a privilege against self-incrimination, which means that if you wanted to testify in your case, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, Your Honor.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described?
Yes, Your Honor.
You also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury, and also the requirement that you be found guilty beyond a reasonable doubt.
Yes.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
Right. Do you further understand, Mr. Smith, that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea?
Yes, sir.
Now, are you aware of the possible penalties that could be imposed as a result of this guilty plea that you're attempting to make?
Yes, Your Honor.
Okay. Let's go over those. Felony theft is a level 9 felony. In the most favorable criminal history category of I, you could receive as little as a 5-month prison sentence. However, in the worst criminal history category of A, you could receive up to a 17-month sentence. So the sentencing range is 5 to 17 months in prison, depending on your criminal history. Mr. Smith, as you participate today, we do not know with certainty what your criminal history is. You better than anyone else here should know what your own criminal record looks like, but that would be researched by the Court Services Department. And based on the outcome of their research, as of the date of sentencing, that determines where you fall along the level 9 grid line under the Kansas Sentencing Guidelines Act, and then you'll be sentenced accordingly. You understand that?
Yes, Your Honor.
You also understand that at sentencing, if it turns out you have 2 or more person felonies on your record already, you would be presumptive prison in this case. Do you understand that?
Yes, sir.
You also understand that you could receive up to a $100,000 fine for this offense.
Yes, Your Honor.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution of victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you would do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, Your Honor.
Mr. Smith, do you understand that both probationary and post-release supervision terms generally start at 12 months in duration, but can run up to 60 months under certain circumstances? Do you understand that?
Yes, sir.
Did you have the concept of Senate Bill 123 explained to you?
Quite a while back, yes.
Well, Senate Bill 123 is a state-sponsored substance abuse treatment program that some offenders qualify for. If you are such an offender, you may be mandatorily required to participate in a state-sponsored substance abuse treatment program for up to 18 months under community correction supervision. Do you understand that?
Yes, Your Honor.
Okay. You also understand, Mr. Smith, that the Kansas Sentencing Guidelines Act is much more than the grid that this court referred to earlier. It's an entire book of sentencing rules and laws. Do you understand that if any special rules apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you understand that?
I understand that, but I didn't know that it affected it in any way.
Well, I don't know that you have any special rules that will affect you either. I just want to make you aware that there's the possibility of it. You understand that?
Yes, Your Honor. If provided, would I be able to speak to my attorney about that?
Yes, if you need a moment to speak with him, we can allow that.
Yes, please.
All right. We'll take a brief recess here and allow Mr. Favre to have a breakout session with his client. All right, Mr. Smith, after this break, are you ready to proceed further with this felony plea?
Yes, Your Honor.
All right. So Are you satisfied with the services and advice given to you by your lawyer, Mr. Favre?
Yes, Your Honor.
Okay. Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentencing or any other type of threat or promise?
No, Your Honor.
You understand, Mr. Smith, that if there have been any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, Your Honor.
So how do you formally plead to the charge in count 1, felony theft, at this time, Mr. Smith?
Guilty, Your Honor.
Okay, let's talk about what happened. According to the state's charging document, Mr. Smith, this happened on or about August 3 of 2025. Is that when it happened?
I believe so, Your Honor.
And it happened somewhere in Butler County, Kansas. Where was it?
Dearborn Street, or the alleyway behind Dearborn Street.
Okay, Dearborn,
in Augusta.
to knowledge, is in Augusta, Kansas. Is that where it is?
Yes, sir.
In Butler County.
Yes, sir.
All right. Theft involves a taking, stealing, essentially. So what was taken here?
A motorcycle.
All right. And you did not have the permission of the owner to take it?
No, sir.
Did you take it with the intention of permanently depriving the owner of the benefit of that property?
Yes, Your Honor.
And do you acknowledge that the value of that motorcycle was more than $1,500?
Yes, Your Honor.
Okay. So do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for felony theft, a severity level 9 non-person felony as charged in count 1?
Yes, sir.
Mr. Favre, do you know of any legal reason why the court shouldn't accept your client's plea?
No, Judge.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
All right, Mr. Smith, do you know of a legal reason or any other good reason why the court shouldn't accept your plea here this afternoon?
No, Your Honor.
The court will accept the guilty plea made by defendant Smith and finds that that plea is made voluntarily. He has an understanding of the nature of the charge against him and the consequences of the plea, and a factual basis for the charge does exist. The court finds him guilty pursuant to acceptance of his guilty plea and adjudges him therefore convicted of felony theft, a severity level 9 non-person felony. Count 2 is dismissed pursuant to plea agreement. The court orders a pre-sentence report be prepared to accurately determine this defendant's criminal history, and the court will set an appropriate date for sentencing. Counsel, I propose 1:15 p.m. on Wednesday, December 31.
That works for me.
Ms. Norris?
Yeah, it looks like that'll be fine.
What day was that?
Court will set sentencing in this case for 1:15 p.m. on Wednesday, December the 31st. Mr. Smith, several orders the court's making regarding you right now as a condition of your bond. Number 1, that you appear at the Butler County Judicial Center where you are today and no other location for your sentencing Wednesday, December 31 at 1:15. You'll want to come in a little early and get checked in so that we can get started on time, okay?
Yes, Your Honor.
Furthermore, the court orders as a condition of your continuing bond to fully comply with all pre-sentence assessments. All right, Mr. Smith, you may be asked to do 2 different assessments. One, a risk needs assessment. The other would be some sort of substance abuse evaluation. It's up to you to make sure that you contact the court services department, make sure that those assessments get scheduled and completed so that we don't have any delays in scheduling. Because, Mr. Smith, if you don't take care of business and we have to delay the sentencing, the court's going to hold you accountable for that.
Yes, Your Honor.
Okay, so court services is located right there in the building where you are. If you don't know where it is, security can point it out to you. You'll need to stop by that office immediately after this hearing and then check in with them, let them know that you've pled to a felony and when your court date is, and they'll give you further direction about what you need to do next, okay?
Yes, Your Honor.
All right. With that direction given, Ms. Norris, is there anything further we need to address currently?
No, Your Honor. Thank you.
Mr. Favre, anything further from the defense side at this time?
No, Judge. Thank you.
All right. Mr. Smith, do you have any questions about what we've done here today?
You said I needed the risk needs assessment and
a substance abuse assessment.
Okay.
Court Services Department will talk to you about what assessments are necessary, okay?
Yes, Your Honor.
Okay. All right. Go over to the Court Services office right after court. If there's nothing further, the John Robert Smith matter will be in recess at this time, and this meeting may be ended for all.
Thank you.
Kansas versus John Robert Smith. It is case number 2025 CR 350. Amber Norris appears for the state of Kansas. Joseph Favre, as defense counsel, separately from his lawyer by Zoom, is the defendant, John Robert Smith. This matter comes before the court at this time for sentencing. The court's docket notes indicating that the defendant appeared before this court on November 5, 2025. At that time, he entered a plea of guilty to count 1, felony theft, a level 9 felony. A pre-sentence report was ordered. Sentencing set for today. The court has received a completed pre-sentence investigation report compiled by Jessica Morgan, pre-sentence investigator, who is present on the meeting with us. I trust each attorney's received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No objection, Your Honor.
Is there any objection by the defense, Mr. Favre?
No objection, Your Honor.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score B, and the court will proceed further accordingly. Ms. Norris, are you aware of any legal reason why sentence should not proceed in this case here this afternoon?
No, Your Honor.
Mr. Favre, are you aware of any such legal reason?
I'm not, Your Honor.
Mr. Smith, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with sentencing at this time?
No, Your Honor.
We'll proceed further then. Counsel, I am aware that there's been a motion for a departure sentence filed in this case. Mr. Favre, you may proceed further on your motion for dispositional and durational departure findings.
Thank you, Your Honor. Your Honor, we are requesting the court make those dispositional departure findings today. Mr. Smith is a young man. He's 24 years of age. I apologize, 25 years of age, my mistake. And he has had a somewhat rough criminal history, but all of that was when he was 19 years of age. And what we're asking the court to consider is that since his rough childhood and the criminal history in the PSI reflects that he has a significant juvenile history, as well as some cases, mostly flee and elutes, that occurred after when he was 19 years of age. Since that time, though, he has had a good record in the community rebuilding his life. We're asking the court to consider that and not to stymie his progress by sending him to the Department of Corrections at this time. There's a couple factors we'd ask the court to consider. First of all, in support of the idea that he's rebuilding his life, we've attached proof of his employment. He does have good employment at Amazon. He has been working at that job for 15 months now. He makes $19.10 an hour. It's a full-time job. We also sent in late, just recently, a letter from a former worker of his that testifies to his conscientiousness as a worker. We asked the court to consider that as well. Mr. Smith has held this job down, has excelled at this job, has been promoted, and he is being successful in the community with that employment. In addition, he's recently started addressing some of his underlying motivating factors for his criminal history. He's getting himself into mental health treatment. He's starting next week a Bible study group that he is joining with the Men of Recovery Unlimited, and he also is he also has started mending the fences of his family, with which he was estranged for quite a while. His mother is back in his life. She has significant health issues. He is trying to support her. in essence, the overall picture of this is that Mr. Smith has made significant efforts to try to be a successful member in the community and to fix his wayward past. Now, normally, if this was a drug case, and even in this case, he would be screened for Senate bill and would possibly be discretionarily Senate bill. And he was screened. I contacted Ms. Morgan for Senate Bill Plus. Because he has only level 8 through 10 felonies, he could potentially have been Senate bill eligible as a discretionary measure. However, he's been sober for the last 6 years, and so he scored very low on his alcohol and drug need assessment. And because of his own taking responsibility for his sobriety, it makes him ineligible for the state program that would have normally placed him on probation to be in the community. I think that is a positive in his consideration. And we'd ask the court to consider it as such. Lastly, Judge, he's taken responsibility for this quickly. He entered a guilty plea. It was his first preliminary hearing setting when he did that. He's agreed to take full responsibility for the restitution in this matter. He has, by his own admission, just made a very bad mistake here. He saw the bike. He took the bike. It was a mistake. The bike luckily got returned. There was some damage. He's willing to take responsibility for that damage. The state also has agreed to stand silent because of that. We ask the court to take into consideration the state's agreeing to not directly oppose the departure motion as a factor in considering this departure request. So we are asking the court to depart from the normal presumption, place Mr. Smith on probation with community corrections. In the alternative, if the court is willing to not consider the departure, we'd ask the court consider offering him a durational departure to a lesser amount of time, because ultimately any time he is serving in is going to significantly derail the progress he's already made, Your Honor.
Very well, Mr. Favre. Ms. Norris, did the state wish to make an argument in regards to the departure motion?
No, Your Honor.
All right. Anything further? I will note, Mr. Favre, that the court did receive the Heather Reynolds letter dated 12/30 of 25, which I think was the document that you had referred to earlier in your argument. Is that correct?
That is correct, Your Honor, yes.
Court is aware of it and will consider it. Closing out the departure hearing, the court will ask, is there any victim or members of the victim's family present who desires to address the court in relation to this sentencing? Court finds no such persons present, so at this time the court will ask for formal recommendations from counsel regarding an appropriate sentence, beginning with Amber Norris on behalf of the state of Kansas.
Your Honor, regarding the theft, count 1, would ask the court assign the 13 months, the mitigated sentence in Department of Corrections. Defendant could earn up to 20% good time credit and would be subject to 12 months post-release. The presumption, as noted in the PSI, is prison. Defendant has 1 day of jail time credit. Ask the court assess the cost of the action to the defendant. Court will need to address court-appointed attorney's fees and the bid's application fee as Mr. Favre is appointed. And Your Honor, there is restitution. In this case, the court, the state forwarded to court and counsel the victim impact statement that was forwarded to our office. It was not attached to the PSI that I'm aware of, so we did forward that to the court and counsel. It is for $510.81, which basically is the replacement of the ignition switch. The estimate from J. Hatfield Motorsports is attached. And then it shows the replacement of same also attached, which is $510.81. We would ask the court order that as restitution to the victim. Would ask that the defendant, if the defendant agrees to that he do so verbally on the record based on some newer case law. Otherwise, Your Honor, state has no further recommendations for the court at this time.
Very well. Mr. Favre, your recommendations regarding an appropriate sentence?
Judge, we ask the court to place Mr. Smith on corrections and grant the departure motion. No objection to the standard conditions of probation listed in the PSI. We will note that Mr. Smith is, we will say again, Mr. Smith is willing to take responsibility for the restitution. Court can inquire of him. That amount is fine. I've already talked to Mr. Smith about that amount, and he does, as I noted, work full-time and is able to and willing to take responsibility for that. We would ask the court to consider whether it wants to consider his attorney's fees given the restitution. He does make $19.10 an hour, so I'm not sure if that's necessary, but the court-appointed attorney's fees in this matter are $1,100, and he does have other court costs and restitution that he'd be required to pay.
Very well. Thank you, Mr. Favre. Mr. Smith, a restitution amount has been proposed to this court in the amount of $510.81. Are you in agreement that that's a proper amount to assess for you to pay in this case?
Yes, Your Honor.
All right, very well. Do you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court?
I agree to the fines and fees and everything that has been brought to my attention due to the fact that I am working constant throughout the week. Recently, the only days that I had off for the past month and a half was Thursdays. Other than that, I'm the sole household income to pay rent and utilities and other stuff like that. Granted, they're not my actual kids. I do have fur babies and reptiles that we do take care of as well. So it would be a very big impact on my significant other if I do be placed in incarceration.
All right. Anything else, Mr. Smith?
I take full responsibility for my actions due to the fact that it was a very inappropriate decision of mine to make. I take responsibility for what I did, and I am very apologetic about it. It has weighed a lot on my shoulders ever since that day. And I will do everything and anything that I can to make amends and also do what I need to get counseling, therapy, and better myself as an individual and get my thought process back on track.
Very well, Mr. Smith. Court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of felony theft, a severity level 9, non-drug, non-person felony, in which the defendant has a criminal history score of B, thus placing him in grid box 9B. The court hereby sentences the defendant to a term of 13 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. The court finds that in grid box 9B, Mr. Smith is presumptive prison under Kansas law due to his criminal history. Court has considered the motion for both a durational and a dispositional departure in this case. Court does find that the defendant in this case has accepted responsibility for his actions, that the state does not actively oppose a departure sentence in this case, and in the view of the court, the current crime of conviction combined with evaluation of this defendant's criminal history does not merit an initial prison sentence from this court. This court will find substantial and compelling reasons, therefore, to grant a dispositional departure in this case. Court will place this defendant on probation initially for a 12-month term to be supervised by community corrections. Community corrections supervision is deemed appropriate because the defendant scored high on his LSCMI, also because this is a departure sentence from a presumptive prison sentence. Conditions of that probation will include reporting to an officer as directed, Defendant must observe all laws. He shall not possess or consume alcohol or illegal drugs while on probation. At a supervising officer's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, gain and maintain employment suitably throughout his probationary term, notify his supervising officer of any changes in employment status, residence, telephone number, or email address within 24 hours of any such change taking place. He shall have no contact with the victim in this case, abide by any curfew or travel restrictions imposed by his officer, avoid disreputable characters and places, not have in his possession firearms or dangerous weapons, follow standard conditions of probation and community corrections placement, and make monthly payments on his obligations in a manner acceptable to the court. Those monthly payments shall include amounts for restitution to the victim in the amount of $510.81, a felony docket fee, felony probation fee, community corrections fee, bids application fee of $100, and $300 in legal fees. Court finds that paid out over time, that modest amount of legal fees should not work a burden or hardship on this defendant or his family. Further, Mr. Smith, theft is a huge problem in Butler County. And in fact, I think in all counties of our state, your behavior must be deterred. I don't think that you took seriously your actions when you stole this motorcycle and apparently damaged the ignition so that you could steal it. So this was a deliberate act. It wasn't one of impulse. It took some real effort to steal this motorcycle and go off with it. I do understand the statements have been made about your progress, your work situation, your family situation, and the like. But Mr. Smith, you didn't care about any of that when you stole this motorcycle. And you're a guy that's in the B box on the grid. In other words, any felony you commit for the rest of your life, you're going to be presumptive prison. You didn't care. Now, the court has made findings to support a departure sentence, as the court found earlier, Mr. Smith. I don't think you're a correctional facility case at this point. You're not a prison case. You should have an opportunity to be on probation in the community. But the court's going to order you to serve the maximum amount of jail time as a condition of probation that it can order. And that is a maximum of 60 days. You have 1 day of previous credit. So the court's going to order you into custody today to serve 59 more consecutive days in the Butler County Jail as a condition of probation in this case. You need to have some shock here, some disruption of your life, Mr. Smith, to drive home just how close you are to just being incarcerated and locked away in a prison somewhere. And then maybe you'll think twice about stealing someone's motorcycle or doing any other theft or crime in Butler County, Kansas. So the court will order 59 days more. It's actually a 60-day sanction with 1 day jail time credit, so he has to serve 59 more days. I've considered the possibility of work release in this case, Mr. Smith, but I want this to be a disruption of your life to the extent that every single aspect of it has been touched by your criminal behavior. And so the court is going to deny any release privileges. You're going to serve 59 more days starting now. Now, I hope that doesn't cause true hardship for anyone else. But again, this is something you should have thought about. Furthermore, Mr. Smith, you certainly didn't have any guarantees coming into court today that you weren't going to go to prison. In fact, you were presumed to go to prison. So I presume that you've made proper arrangements which took into account that you very well may be going away for a very long time. Did I see you raise your hand, Mr. Smith?
Yes, Your Honor.
For what reason?
I will end up losing my job for doing time.
You should have thought about that. I hate to see you lose your job. If you're really that good of a worker at Amazon, they're going to hold your job for you or they're going to hire you back. And if you do lose that job, that's regrettable, Mr. Smith, but you caused it, no one else. So work release privileges is denied by this court. Court's already dealt with the issues of restitution to a victim and jail time credit. I'll advise the defendant that he may have the right to seek expungement of this offense in the future. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, Mr. Smith, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain circumstances, a criminal defendant in Kansas may have the right to appeal their conviction to an appellate court having jurisdiction. And if the defendant is unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, Mr. Smith, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Because the defendant is going to be incarcerated for the next 2 months, the court will not require a payment in this case until March of 2026. Court will expect regular and consistent effort on these obligations. Court will require a $100 a month minimum payment, starting with the calendar month of March 2026 and all subsequent months until his case is paid in full. All right, Ms. Norris, are you aware of other sentencing-related matters which the court still needs to address?
No, Your Honor. Thank you.
Mr. Favre, are you aware of any other sentencing-related matters that still need to be addressed by the court?
I'm not, Your Honor, no.
Ms. Stanfield, as the representative here from Community Corrections, I'll first ask you, do you need any clarification regarding the court sentencing orders in the Smith case?
No, Your Honor.
What direction would you give Mr. Smith?
If before he's taken into custody, if we could have a breakout room where I could get address, email address, phone number, and give him Mr. Ketley's name and number.
All right. I think we can accommodate that, Ms. Stanfield. When we recess the case, Mr. Smith, I'm going to ask you to stay in that location and hope the officers are hearing this. I want you to meet with your community corrections officer before you're taken to jail. And she's going to give you some direction about what you need to do when you get out.
Yes, Your Honor.
Oh, I'm sorry.
Okay. Mr. Smith, do you have any questions regarding the court sentencing orders?
No, Your Honor.
All right. I hope you're successful on this probation program. Again, this was a dispositional departure case. If you come back before the court, you very well may be looking at a prison sentence. So don't let that happen. Do everything else that you're supposed to do. Further, I'm going to ask the security officer that once he's done with Ms. Stanfield, if he has a cell phone on him, I would just ask you to consider, and I don't want to interfere with sheriff procedure or security, allow him to make a call to someone, either his employer or a significant other, so that he can report to them what's happened in court. I think that
Yes.
would be a reasonable accommodation to make under these circumstances. But again, I'll leave that to the sound discretion of the security officers. Seeing nothing further, the court will recess this proceeding as the sentencing is concluded. We will leave the Zoom meeting open for allowed conferencing between Ms. Stanfield and the defendant. Everyone else can leave the meeting at this time.
And once again, ladies and gentlemen, another day of court has come and another day of court has gone. Of course, that court was actually from yesterday because there was no court on New Year's Day. It was a court holiday for pretty much everybody except for people who were, first appearances and whatnot. And we see a lot of that stuff. But tomorrow, Friday, ladies and gentlemen, the second day of January is going to be probably a busy one, I anticipate. So keep an eye out. We will be live again tomorrow evening. Same Wolf time, same Wolf channel. We'll be right back here with more daily dockets. Talk about, enjoy together. And don't forget, the weekend show is coming up We're going to watch some Thurston County protection order craziness for at least half the show. The rest, I hadn't really made my mind up yet. Ladies and gentlemen, thank you for hanging out with me tonight. It's been amazing. Chat's been awesome. And I do thank all of you for coming out, participating, and commenting about these court cases with us. I'm your Lone Wolf Usul. I'm your humble host for these here videos, your curator for this here court gallery. And I want to say thank you. It's going to be a great year. I love you guys. I'll see you next time. I'm Lone Wolf Usul, and I'm out. For those of you who have seen Stranger Things Season 5 finale, the wolf believes.